What's up, everybody? So Steven Avery has wrote another letter to the Court of Appeals clerk in Madison, Wisconsin. Now remember, he did this a few months ago as well, and now he has done it again. It looks like he wrote the letter on July 30th, and it was received on August 4th, 2023. I have the letter. I'm going to put it up on the screen for you so you can check it out as well, and we're going to go over it here. It says, to the Court of Appeals clerk in Madison, Wisconsin, from Steven Avery, inmate number 122987, a letter and a complaint. It's dated at the top there. You see August 4th, 2023. This letter is from Steven Avery, twice wrongfully incarcerated Wisconsin man who had his life stolen from him. Steven Avery awaits a response from the Sheboygan Circuit Court judge regarding his most recent Second Amendment notice of motion and third motion for post-conviction on relief pursuant to Wisconsin Statute 974.06 and 805.15. This motion was filed on January 24th, 2023. As of May 24th, 2023, there has been no response. In accordance with SCR Chapter 70, Rules of Judicial Administration, Assignment of the Circuit Judges, the following is noted. The Chief Judge, by order, may also assign an active judge of the Judicial Administrative District to relief conjunction to expedite disposition of litigation or to assist in any branch of circuit court in the Judicial Administrative District. That is a lot of big words for me. Note it clearly in SCR 70.36, Judges and Circuit Court Commissioners certification of status pending cases. Every judge of a circuit court shall decide each matter submitted for decision within 90 days on the date which the matter is submitted to the judge in final form, exclusive of the time the judge has actually disabled by sickness. If a judge is unable to do so within 5 days of the expiration date of the 90-day period, the judge shall so certify in record of the matter and notify in writing the Judicial Administrative District in which the matter is pending. The period is thereupon extended for one additional period of 90 days. The subsection appeals to the assigned reserved judge. B. The exercise of its superintending and administrative authority over all court, and upon written request from a chief judge, the Supreme Court may extend the period specified for decision in specific matters and EXIGENT circumstances may require. With the first 10 days of each month, every judge of a circuit court shall execute and file with the office of director of the state courts a certification stating that there are no matters awaiting decision beyond the 90-day, or if extended by certification and notification, the 180 days specified in sub 1A. But if the 90-day period has extended by certification and notification, there are some typos in here. You think somebody would have maybe proofread this. A copy of the certification and notification shall be attached to the certificate, or if there are matters so pending, a certificate setting forth the name and docket number of each matter, the court in which it is pending, and the date on which it was submitted to the judges in final form. Number 3, certificates filed under sub 1 or 2 shall be retained by the office of director of the state courts for 10 years from the date of filing. The office of the director of state courts shall send a copy of certificates listing pending matters to the chief judge of the Judicial Administrative District in which those matters are pending, and shall notify the judge of a Judicial Administrative District of the failure of a judge within the district to file a certificate pursuant to this subsection. The direct of state courts pursuant SCR 7.10 and the chief judge pursuant to SCR 7.19 shall assign judge as needed or take other steps for the timely disposition of judicial business to assist a judge who has filed a certificate under sub 2A or 2.3. Failure of a judge to comply with the requirements of sub 1A or sub 2A may result in one or more of the following measures: change of the judge's assignments pursuant to SCR.70.19, 3A, referral of the matter by the director of the state courts to the Supreme Court for the initiation of contempt proceedings, referral of the matter by director of the state courts to the Judicial Commission for investigation of possible misconduct. Mr. Avery's reply to the state's response opposing a motion for an evidentiary hearing and post-conviction relief under Wisconsin Stat 974.06 was filed on January 26, 2023. The responsible official, the judge, is obligated per SCR 7.036 to the following above-mentioned procedure for all pending cases. The 90-day period has now lapsed, where this is the certification and notification as prescribed above. Has the judge been disabled by sickness? Has the judge failed to comply with these requirements? If so, what remedial measures have been recommended? Failure to keep from harm and color of law abuses. I am 100% innocent man. And what does it take for an innocent man to prove my innocence in the court of law? Steven Avery, Justice. And then it has Steven Avery's signature, dated 7/30/2023, July 30th, 2023. Steven Avery, Fox Lake Correctional Institution. The address in Fox Lake, Wisconsin, there on the bottom left. So that's the letter Steven Avery wrote to the court. The judge has way more than elapsed the 90 days. So it's going to be extremely interesting to see if and when they respond to this letter. If Kathleen Zellner had anything to do with this letter. Her name is nowhere on it. I wonder if she's aware that he sent it. So from January 2023 to today, which is August 10th, 2023, way more, obviously, than the 90 days have elapsed. What do you think? What do you think is going on? What do you think the judge is going to state about taking way more than the 90 days to respond to this letter that Kathleen Zellner submitted in January 2023? Let me know. Leave some comments below. I hope you're having a good day, and I will see you again soon.